Supreme Court is weighing the interaction between government and social media in a landmark free speech case. The case stems from the Biden administration's early efforts to push platforms to take down content it deemed misinformation about COVID and the 2020 election. For more, we are joined by CBS News legal contributor Jessica Levinson, and she is a professor at Loyola Law School in Los Angeles. Jessica, it's good to be back with you again. What stood out to you at an oral argument on Monday?
I think what stood out to me is this. I suspect this will be a 6-3 decision, but not the way we typically expect 6-3. I think that we will have 3 members of the conservative wing join with the liberals and say the government is entitled to interact not just with newspapers, not just with magazines, but also with the new media platform, social media. And that as long as it doesn't amount to coercion, they can encourage, they can push, they can cajole, but they can't coerce. And I think part of what we see here is that this is a question that doesn't divide along partisan lines. It divides in part along ideological lines, which I would offer is still different, and on personal background, in the sense that you have Kavanaugh, you have Kagan, who both worked in the White House and understand how White House officials do speak to members of the media and now social media platforms.
Well, you know, it's such a great point. Let me ask you about something that Justice Samuel Alito said, because I think it goes right to your point about those who have worked inside a White House and those who might be unfamiliar with the practice of things. Let's listen to what Justice Alito said, and then I'll ask you about it.
When they're unhappy, they curse them out. There are regular meetings. There is constant pestering of Facebook and some of the other platforms. So it's treating Facebook and these other platforms like they're subordinates. Would you do that to the New York Times or the Wall Street Journal or the Associated Press or any other big newspaper or wire service?
As someone who's covered a White House, the answer to that, Mr. Justice, is yes. They would do that, and they would do it often. But to you, what did that tell you about the difference between those who worked inside a White House, who understand how things work, and those justices who don't?
Well, the question is probably the answer here, in the sense that personal experience does make a difference. And we see this in so many different areas. But I certainly think when you have, for instance, a former Solicitor General who comes to the Supreme Court, when you have somebody who's worked in the White House counsel office, and when it comes to these questions of executive power, they do have a different perspective. I will also say, not in Justice Alito's defense, but maybe to explain this more broadly, the court has increasingly been taking these questions of what does free speech mean in the internet age and what is the government's power in the internet age, particularly with respect to social media companies. And what you see is that there is a wide variety of understanding of what social media companies do, not unlike, frankly, when you see tech giants go and testify before congressional committees, and you have some questions that frankly read like this question, like, we have some news for you here.
What, if there is going to be an emerging standard to come out of this, does it have to be, because obviously a White House is powerful and the federal government is powerful, and so I shouldn't snicker at what that might feel like to be on the receiving end of that. But there surely has to be some public interest, I would think, in terms of a test going forward, so that if a White House talks to one of these social media firms, they have to have some business. It can't just be, hey, be a little nicer to Joe Biden.
It can't be. And I think that because this is largely a matter of first impression, what we will likely see is either a fairly flexible standard that says government officials, you can argue not just on behalf of yourself. It's not just that you can put out a public service announcement, but you can push social media companies, particularly to maybe deplatform people who are engaging in propaganda of misinformation and disinformation involving things like the election or COVID-19. But you can't cross the line to the point where you don't have the ability as a private company to say no. So my guess is what we maybe see in the beginning is a flexible standard, and then what typically happens, the cases that follow trying to interpret that standard will bring a little bit more clarity.
And so in the short period of time we have left, do you have any thoughts about how this might affect exactly what you were just talking about, which is misinformation, disinformation with respect to the 24 election?
So my understanding is that what happened in the courts below, what happened in the Fifth Circuit, has already chilled government officials from interacting with social media companies. If the Supreme Court comes out with a strong statement that says it's okay, you can talk to them as long as it's not coercion/censorship, then I think we could see not a revival to back where the Biden administration was when they came in, they said, this is a huge problem, but we could see some tamping down of that disinformation, misinformation as we enter November 2024.
Jessica Levinson in Los Angeles, extremely helpful as always. Thank you.